these series of modules would not have been available without the cooperation and the participation of the Legal Aid Board. So I want to extend a very big thank you to the Legal Aid Board for their cooperation and collaboration in this project. The title of the webinar is Separating Families: Alternatives to the Court Process, including Mediation. And this section will be delivered by Aisling Maloney, as a solicitor from Ennis. And the second part of the webinar is focused on legal information, advice and registration in relation to parental separation. And that will be presented by Tony Louise Monaghan. Thank you very much. We hope that you enjoyed the module this afternoon, that you get a lot out of it. I'm going to hand over to Aisling now.
Thank you, Anne. I hope everybody can see me. My name is Aisling Maloney. I'm a solicitor. However, for the last 10 years, I've been working full-time as a mediator, both in private practice and with Family Mediation Service. So today what I'd like to do is give you a broad overall perspective on mediation and how it operates within the family realm. I work both in Dolphin House and Ennis Courthouse, predominantly dealing with matters in the District and Circuit Court. Okay, so just to start from the outset, I'd like to give you a definition of mediation. So mediation is an alternative method of dispute resolution to the adversarial process. It's used in many areas within all aspects of society, that being industrial and workplace disputes, commercial disputes, community disputes, international disputes, and family disputes. And the definition as to what is mediation is: it is a voluntary, confidential, non-adversarial conflict resolution process in which a neutral third party assists parties to a dispute to reach mutually acceptable agreements. Family mediation then is a process in which a professional mediator assists those involved in family breakdown, and in particular separating or divorcing couples, to communicate better with one another and reach their own agreed and informed decisions concerning some or all of the issues. And my role in that is a neutral, independent third party. Okay, so the principle underlying mediation is that couples who are in dispute have the opportunity to negotiate their own agreement with the help of a mediator. And my role is to assist the couple in negotiating that agreement. I'm not there to advise them on legal or other issues. It's not a legal advice service or a counselling service. The principle underlying mediation is that couples are taking responsibility for resolving their own issues, as opposed to decisions being made for them by a third party or the court. Now, the core principles within that are impartiality. I must remain impartial. No matter what my views of the circumstances of the case, it does not come into the room. Empowerment. Ultimately, there can from time to time be a power imbalance in the room. So I'm trying to ensure that both parties have an equal opportunity to have their say without verbal interjection from the other side, with the view to bring that power imbalance back in check. Then confidentiality. A key tenet of mediation is that it is a confidential process, and the mediator will not testify on behalf of either party in court. The only time, all discussions arising out of mediation are confidential, and the only time a mediator would remove that veil of confidentiality is when a child is at risk. So competence, obviously a level of competence in terms of training, etc. Fairness, absolute ability to maintain an unbiased nature in the room. Psychological well-being, ensuring that there's full capacity to make decisions in the room. Self-determination, that's key, that parties themselves are making their decisions. I'm not adjudicating, I'm not imposing a solution, I'm merely facilitating that option for parties to reach their own self-determination. And then full and frank disclosures. So obviously, when decisions are being made about financial matters in mediation, it's important that there's full and frank disclosure made by each party of all financial and other relevant information, and those financial documents will need to be brought to mediation. I would insist that obviously, while attending mediation, that couples are seeking legal advice on any matters being discussed in order to be fully aware of the consequences. So, of all of those different proposals, and obviously then qualifying parties can seek legal advice from the Legal Aid Board. The values in mediation are really the key of mediation is that you're preserving the dignity of each person, and you're treating each as an adult and their ability to make decisions, that decisions aren't being imposed on them. There is no undue influence. There's no decisions being made in duress. And you are acknowledging in the room that all individuals are entitled to fair treatment, and that an equitable distribution of property and financial security and freedom, without any interference from any third parties or any extended members of either family, is really important. The decisions that are being made in the room are their own. And I would be very clear on that. And I think that's where it's very important that individuals, when they're coming into mediation, they've had at least one consultation with the solicitor so that they're fully clear on what their rights and responsibilities are. So, once in the room, then my task is to, number one, establish rapport. So I would meet each party individually first. I need to establish a rapport with that and each individual and make sure that they feel comfortable with me and build that level of trust. I have to build confidence in the other side so that they know that in that space, I'm maintaining that level of neutrality and their ability to represent themselves and be heard. And I'm there, obviously, not as a judge in any fashion, that there is no judgment in that room and the parties have the freedom to speak. And finally, I'm balancing that participation so that no party is dominating in the room, and ultimately both parties are having an equal opportunity to have their say. So the techniques that would be used in that, obviously, I used to work as a solicitor, so it took me quite a while to fall into the realm of wearing a different hat of mediator. I'm not advising clients, and that's key. I'm ultimately, giving parties that opportunity to present themselves in terms of what's the best possible outcome for them. And in order to do that, obviously, number one is listening, and then empowering that person to put forward and propose the specifics that are best going to meet their needs. And obviously with the children at the top of the pyramid, that they're advocating for their child in the room. And then I'm questioning them both for specific options that there may be. So they will both potentially propose different scenarios or outcomes pertaining to parenting, for example, or financial solutions. And then we're questioning those options and we're trying to develop those options and get clarity around what those potential scenarios might look like so that people are future focusing and they're really getting a sense of the decisions that they're making. Reality testing also for me is something that, I do like the parties to understand that there is certain underlying principles in family law, that being proper provision. So they have to be clear that the decisions they're making and putting forward are going to meet, that test when they go in front of a judge, and that the judge grants them a decree of divorce on foot of the decisions that they have made. And it's just being very clear in that regard that everybody is fully aware that there is a test that needs to be met, and that underlying principle again is proper provision. So reframing, simply to clarify that for you, that's what I would see, with couples is majority of couples speaking somewhat different languages. Okay, so their communication has broken down, and when they're trying to negotiate terms for separation, sometimes on their own, they can't hear each other. And if I can come forward and use certain techniques, like what I would use a lot is neurolinguistic programming, whereby parties, generally men, not to use too many generalizations here, but generally men would speak in a very visual way, and they would say things that they see things as, this is the way it should be done, this is how I see it. Whereas women would talk very much kinesthetically about their emotive space, and they might say, well, I feel it should be done this way. And oftentimes when people speak in those different modalities, they don't tend to hear. So I would reframe within the specific modality of the other person. And sometimes it's very interesting. They can actually, the way it lands with that person is they interpret what that party is saying in a way that's more palatable for them. And it can shift the dynamic in the room, and it can bring clients to a space being willing to hear each other. And again, balancing, that's about giving parties that equal opportunity to have their say. So family mediation in this country, just to tell you, there are two options. Okay, so there's a free state-run service known as the Family Mediation Service, and obviously that's delivered by professional trained mediators. And from my perspective, working within that service, obviously, as I see it, there are really a cohort of mediators within the family law realm that are the most highly trained, because they're constantly, you know, going through rigorous requirements first in order to become qualified to be part of that service, but then an ongoing CPD arrangement that's very rigorous. And then the private mediators are sourced through the Mediators Institute of Ireland. But I would say to anyone who's seeking a private mediator from that source, that they really check the credentials and experience of the mediator. And, you know, within that website, you have registered mediators, but you also have what's called advanced mediators. So I would be looking for advanced practitioner status for anyone to take on a case within the family mediation realm. Now, the Family Mediation Service, just to say, I've mentioned it's a free service, but just to give you an idea of the history of it and how it has developed and how we've seen so many changes within this area at the moment. So it was set up as a pilot in 1986, and then in 2003, it fell under the umbrella of the Family Support Agency. And in November 2011, it then moved over to the Legal Aid Board, which was actually a great move for the Family Mediation Service because it brought us within that legal remit. And it meant all law centres and mediation offices were starting to co-locate and work together. So from our outset in 1986, there was one office in Dublin, and as of 2021, there are 17 countrywide, 8 full-time and 9 part-time offices. And also there's a number of mediation offices in district court venues. And that's due to increase. An awful lot of the judiciary are seeking to have an on-site mediator to deal with cases as they arise. So, you know, it's very much something that's a growth area still. And obviously, I suppose we've come a long way in society in that time, in that the client profile has changed so much. So as of now, what you're looking at are clients, you know, where they have court-ordered mediation, which is something I'm not necessarily a fan of. I don't feel mediation should be directed through the court because it is inherently a voluntary process. So parties, in order for it to work, they really have to assert their willingness to participate in it in order for it to really work in a positive way. You have mediation for non-nationals. An awful lot of non-nationals would come through our service, and obviously, you know, they may not be legally aided or would be potentially attending court as lay litigants. So the mediation service is of huge value for them. We also provide translators within our service. So we're able to manage non-nationals who have very little to no level of English, you know, and we do provide a translator and operate and can generally reach very robust agreements with non-nationals. And then culturally diverse couples. So we've had to become very much abreast of all of that new cultural, societal change that we've seen in the last decade or so, and really try and assist people with very different cultural views as to how marital separation should be managed. Then you've mediation for couples living here and abroad. At the moment, I'm actually dealing with a couple. One party resides in Canada and the other party is now living in Pakistan. They had started mediation in Ireland, but they need to deal with matters, and I'm continuing to work with them. And I suppose this is the benefit of the pandemic. We've all become so abreast of dealing with video conferencing links that this isn't an issue. And it's fantastic for them because they have no other way of resolving this matter, and they're making great progress. And it's very satisfying to see an outcome, particular for the children obviously involved in that case. So other family related mediation that we would deal with in the mediation service are things like foster parents. Grandparents would be a huge area where you would have grandparents coming in seeking access to a grandchild, you know, in a situation where potentially their child may have passed and they are having limited access to their grandchildren on foot of that, or post-separation. things had become very acrimonious, so therefore they're having difficulties around access, and we would facilitate that. And then care of an elderly relative obviously is becoming a huge growth area, you know, in terms of managing family dynamics in order to reach a resolution around how a member of their family should be cared for. So in terms of family mediation, the issues that we most deal with are, I suppose, the family home would be key, obviously, no family home. So when you're no family home, you're looking at potential availability of accommodation elsewhere, cost of accommodation. You're looking at parenting, coming up with parenting plans. You may have had a situation where one party would stay at home and the other party's out working. Now you're looking at potentially both parents working, how those childcare arrangements would be dealt with, custody arrangements, guardianship and maintenance. And we're also dealing with, you know, other aspects like pensions, insurance, other property, any assets or liabilities the couples may have, additional finances. And then, you know, in the past, when parties had to wait for 4 out of the preceding 5 years before they could apply for a decree of divorce, you often had people coming to mediation to deal with their separation initially and then returning to mediation to deal with their divorce. Whereas now people are generally, I suppose, judicial separation is kind of seems to be disappearing somewhat, because now the criteria for divorce is 2 out of the preceding 3 years of separation. So people are coming and dealing with all aspects of their divorce. But they, you know, in the event of a breakdown in any agreement or a change in circumstances affecting the agreement prior to being legally formalized, the parties can return to mediation to renegotiate the issues in question. So the mediation process, just to give you an insight as to how that works on the ground. Okay, so somebody, for example, comes into one of your services and is interested in mediation. The process is they need to register with the service. So party A would register with the service. They would get our details through the Legal Aid Board website as to which is the nearest available office to them. Register with the service, assert their willingness to attend, and they would inform the other party at that time that they then in turn have to register their willingness to participate. So you've that initial contact from one individual, but the other party then needs to confirm their interest. Now, if there's a challenge whereby they don't want to ask the other party to confirm their interest, or they haven't had that chat and they're trying to tease out the process of mediation, the mediation service can send a letter to the second party offering them an appointment for information to hear about mediation as an option, and to ascertain following that if there is a willingness to participate. So once both parties have confirmed their willingness to participate, then they are put on the waiting list. Now, the waiting list can be quite lengthy, as any public service. It very much depends from office to office and region to region as to how that waiting list is looking at any one time. In the district court, there is more speed. So in the district court, what you're dealing with is custody, access, maintenance and guardianship. And I would generally operate within the court realm and I assist the court. They would assist me in expediting agreements. Mediated agreements would be drawn up and lodged with the court clerk, and then they would be ruled at the following court family law day. So they're cases that would happen a lot quicker than what's known as all issues mediation, where you're dealing with married couples potentially, where we're looking at everything pertaining to separation and divorce. So you're looking at other issues like the pension, like the family home, like assets and liabilities, etc. So there's a slight difference there in terms of waiting time, simply because one case needs an awful lot more sessions than the general district court case, which may need potentially 2 to 3 sessions. So once you're issued with an appointment, then both parties would attend with myself, and that for me happens within Ennis Courthouse, and both parties would attend together. They'd come in, sit down, I would go through the ground rules of mediation, you know, noting clearly exactly what my expectations are of the parties in the room, very much around the area that there's to be no verbal interjections when the other party is talking, that I have the right to suspend or withdraw from mediation at any time. No marital assets may be disposed of by either party unless they both agree. And that my role there, again, just to be really clear on what it is, that I'm not advising. It's not a legal advice service. It's not a counselling service, that ultimately I'm facilitating that conversation. I'm not evaluating for the couple. I'm giving the parties an opportunity to have their say without interruption, and I'm promoting the balanced interests of all parties. But each party has the right to suspend or withdraw from mediation. It's a voluntary process, and that all issues are open for negotiation, okay? Parenting, living arrangements, family, home, financial support, property, education, health, welfare of the children. So yeah, once we've gone through all of that, then all of us would, once that we've understood all of that and everyone in the room is clear on that, then everybody would sign those ground rules, okay? And the next step would be an opportunity for each individual to tell me a bit about their story and give me some clarity as to where they're at. And I would then in turn pose the questions somewhat of the best possible outcome for each individual, okay? From there, then I need to see both parties separately in a caucus session. And that for me is a screening for obviously domestic abuse, decision-making ability and capacity. And both parties are seen separately, but I'm very clear that I'm asking both parties the same questions, okay? And I'm not delving too deep into either side, but I need to get clarity. It's an assessment for me as to how to handle this dynamic in the event that there are any concerns. So then we go through an intake questionnaire. It's for me gathering information, trying to assess the issues that need to be addressed. What are we dealing with here? What properties are we dealing with? What debts are we dealing with? The family home, is it registered jointly? The mortgage outstanding, what's in the family pot in terms of income, pensions, and any and all assets and any monies that may be held. So everything they own and everything they owe effectively. And once we've kind of clarified that, we're looking at the children, looking at their stages of development, looking at the best options for them. We're not delving too much into the options. I'm just getting an overall broad view as to where the children are at and where the parents are at in terms of, I suppose, their collaboration around that piece. And we're identifying the priority. And I would say more often than not, the priority for most couples in mediation is to try and address the parenting side of things and to come up with a parenting plan and to ensure that the children's voice and wishes are being heard. And finally, then at the end of that session, I'll be handing out budget sheets to be completed for the next session with the financial checklist. And that in turn, I suppose, it's to prepare the parties for filling out what would be in time their affidavit of means and affidavit of welfare when they then in turn go to their solicitors. So we're trying to marry the two in a way, not to use a poor choice of words there. However, what we're trying to do is to ensure that they're not doubling up when they're going to their solicitor, and they have clarity as to all of the financial aspects of things that they need to try and gather up. So the mediation process itself, on average, they would say it takes 3 to 6 sessions, but it very much depends on each specific case. So it's a very subjective thing for each couple. And I would just say to everyone as they come in, there is no limit to the number of sessions that are happening that we can provide. But obviously, it's monitored somewhat from a resources point of view within the board, but we have a certain amount of say within that. So if I feel there's progress being made at every session, I will keep going. And I have done up to 10 sessions with couples in order to achieve the best and most comprehensive document we can at the end of it. But if parties aren't participating fully in it, what I may do is, postpone mediation for the time being until such time as they're ready and they're gathering up documents. The worst thing that can happen is parties coming in and frustration building in the room when one party has done the necessary and the other party hasn't. So each session, just to recap again, there's budgets, income, assets, expenditure, option development again, looking at the potential outcomes that we could explore, negotiation around assets, looking at pensions, looking at the annual benefit statement, ensuring that I'm sending parties who have, significant pension pots for expert pension advice so that they can explore exactly, what their pensions, what their retirement benefits might look like, if there was a pension adjustment order. I don't want to give you too much legalese, but if their pensions were carved up in some way, what those retirement funds might look like, and their insurance policies, etc., who's responsible for premiums as they fall due going forward. And actually I would say that aspect of things, budgets as it were, is something that in my experience most parties have never done. And they find it so useful in terms of their life in general, when they can really explore their income and their outgoings and how monies are spent, and also how one person perceives how money is spent within the household and may not be aware of all the additional small pieces and how they add up and how they are being met by one party and not recognized by the other. So yes, parenting arrangements, looking at the children's needs, looking at their stages of development, looking at a co-parenting model and endeavouring to support each other in their role as parents into the future, and looking at potentially extended members of the family and how they might be involved in parenting arrangements, then financial arrangements again, and then drawing together the agreement. So, it starts very much from the space of the willingness to support each other moving forward, and then moving into the space of parenting and the day-to-day aspects of the child's needs, their educational needs, their health needs, all the fundamental aspects of a child's life and how they will be addressed, and the financial aspect of how you will meet all their needs as they're going on, everything down to the nitty-gritty, from the big things like medical, dental, optical, educational expenses, but the day-to-day needs, and really, ensuring that there are no areas that may come up or present as an area of contention going forward.
Aisling, before you go on to the next stage, we've had a couple of questions in. Who decides what questions are to be discussed at mediation?
Okay, well, there's a precedent in that regard in terms of it follows in line separation. So separation as a process obviously involves X number of questions to be answered to ascertain how certain things are going to be dealt with. So I would have a specific agenda at each session whereby we're agreeing. Today, for example, we're dealing with the parenting plan. So that parenting plan would involve the day-to-day needs of the children and the access arrangements for the children and the additional pieces in there, depending on the age of the child and what issues need to be addressed. But each party, Tony, would be given absolute opportunity to express exactly what the areas of concern are for them and what the priorities are for them. So each individual would be given that opportunity. But you are following a specific agenda, and that agenda falls in line with what will in turn look like a mediated agreement at the end. So there are standard areas that need to be addressed.
Another question is this service available to non-married separating couples?
Absolutely, 100%. This process is available to anyone who has children and wishes to decide any arrangements for the child. So in the district court, you're dealing with custody, access, maintenance and guardianship. So guardianship obviously pertains to unmarried parents. And, it can deal with parties who don't have children. So cohabitation rights, for example. So since the 2010 Act, you are looking at the rights of cohabitees. So there may be no children involved, but they need to address their separation and potential rights or remedies that either party may have, and just want to ensure that they reach it in an amicable fashion. So yes, it's open to every couple.
Thank you, Aisling. And there's quite a few questions coming in on the on domestic violence and screening. So and then how do you proceed after that? So one question is, does the screening for domestic abuse take place separately with the participants?
Yes, so that's called the screening process, and that's held in caucus. Okay, so that's where I invite each individual to sit with me separately. Okay, and it's a screening, as I say, for me to address any issues that there may be surrounding domestic violence. And it may be a case that I would view mediation as a process may not be appropriate, and that person needs to have, or either party, the perpetrator or the victim, needs to have some level of additional support. It's a very tricky area, I would say. A lot of people would view it, it's a very polarizing topic. A lot of people would view it that mediation isn't appropriate in any domestic violence situation, because what you can sometimes be doing is giving the perpetrator an opportunity more so to engage in a way that can sometimes exacerbate the situation. However, what we would do, our policy within the mediation service is, if there was an area of domestic violence, generally parties would have been encouraged in advance or prior to meeting me. I can't advise them, you see, so I have to remain neutral, okay? But in practice, what has generally happened in the court realm is that one party may have gone in and is in court, has put in for protection order is in place, and they are awaiting safety order hearing. So in lieu of that safety order hearing, they may have been encouraged by the judge to come to mediation. Now, I'm very clear in the room that in mediation, we cannot discuss matters pertaining to domestic violence. We're precluded under the 2017 Act. So what I'm trying to achieve or see, is there any opportunity in there? These parties, obviously, if there are children, may still need to communicate with each other in some way, but I have to ensure that there is some level of safety at play. So protection order would have to be in place from the outset before I would be willing to proceed, okay? And once that is in place, then if I feel there is an opportunity for parties to communicate in a very facilitated environment in order to achieve an access arrangement, for example, for the children, then I would be willing to proceed in that case.
When there is a history of domestic abuse, how can you ensure there is no further abuse taking place in the process? Some women I work with feel further victimized in the mediation, as there is a power imbalance from the start. So I think you've finished that.
Okay, yeah, I mean, it's a very difficult area. And to be honest with you, when it comes to, I'm very reticent as a mediator to mediate in those situations. So you very much have to be mindful, you know, and ensure that the safety of the individual in the room. So there are policies in place in terms of how we manage that, and how I would endeavour potentially to allow one party leave and bring the other party into the room and ensure that that party has left the building before, you know, you would allow party B to leave. So, you know, I'm very reticent as a mediator to see capacity to negotiate in mediation where domestic violence is at play. But sometimes, and this only came up yesterday, we were doing training with someone in this vein, and it's a very difficult topic for people to navigate as mediators, because there is policy around it. However, a lot of people feel very clearly that mediation is not an appropriate realm where there is domestic violence. On the other hand, other mediators, a lot of people feel, if parties have no other opportunity to negotiate some form of access for the children, is mediation potentially in a facilitated environment a better route to take? Or should you simply advise those clients, or not advise them, but simply direct them, I suppose, to the court system and have a judge make a decision and an order in that regard? So I don't know if I'm giving a clear answer there, but it's a very difficult area. But sometimes people would really ask for an opportunity. Once they have a safety order or a protection order in place, they would ask for an opportunity to sit in a room to try and negotiate access arrangements. And, you know, if there's a willingness on the side of the victim to do that, and you have clear policy and direction, and you know that there is a safety order in place, and you know that person has access to the Gardaí in the event of any potential safety threat, you may proceed on that basis.
Thanks, Aisling. There's still quite a few questions, a lot of interest on this particular topic. there's three questions that are coming in quite similar, and I wonder if the attendees wouldn't mind if I try and put them all together. So the question is, if the domestic violence is identified, do you continue with mediation? Now, I suppose, so that was one, and then the next one was, in the first session when you are screening for abuse, do you stop the meeting to meet with them separately, or is that done separately? And then what was this one was, if the party disclosed domestic abuse in the assessment, how is that managed? So I wonder if those are in joint meetings, it's, if the attendees are asking if at a joint meeting you find or somebody, so it wasn't disclosed at the initial meeting, but at the subsequent meeting when both parties are together, and you hear about a domestic violence allegation, how would you deal with that? I hope I've paraphrased their questions correctly, but come back to me if I haven't. But
yeah, no, so anything pertaining to the screening happens in caucus, okay? So it happens separately. I'm meeting each individual separately, so they have an opportunity to express any concerns they have. But if both parties do not assert that domestic violence situation, then I will not proceed. The only time I will proceed in domestic violence situations is where there is either protection order or safety order in place, number one, and it's acknowledged by both sides. Obviously, it's going to be acknowledged by the victim, but that it's acknowledged also by the perpetrator. And there's a willingness on both sides to wish to negotiate access arrangements, for example, then I will proceed. But I will absolutely, I'm very hesitant where there is a domestic violence situation. However, I'll just give you an example of how, in practical terms, this is coming about. In the court realm, what is happening is the district court judge is often sending clients to mediation who have presented in front of her at a safety order hearing, okay? And I've tried to discuss this on numerous occasions with the judge, that I am precluded from discussing anything pertaining to the domestic violence situation under the Mediation Act, okay? So my only role in that space is if those parties voluntarily both come to me saying they would like to sit down and discuss and communicate around access. And the likelihood is those sessions going forward will be held in caucus. So you will be doing a shuttle mediation service where I'd be seeing both individuals separately. We wouldn't be in joint session, okay? Because in the past, what has happened in joint session is it can just unravel in the room, okay? And there would be safety concerns in the room for me. So I would only endeavour to move forward with parties separately, okay? And see if I can facilitate by caucus and shuttle mediation some form of an outcome for the access to the children.
Thank you, Aisling. And just the one last question then. Is there any circumstances where you won't mediate, for example, if a person has a barring order?
Yes, generally, if people present and there's a barring order in place, I would generally highlight that mediation wasn't an appropriate realm for the parties, and they would just be issued correspondence in that regard. And again, sometimes that happens in a situation where a barring order may be in place and they present in front of a judge pertaining to access or maintenance, and the judge then directs them to mediation. And that's where they unfortunately go around a bit of a loop, and I again then would, having met with them and following an assessment, would assert that mediation isn't the appropriate realm for them.
Thank you, Aisling. That there's
I just want to say in that, Tony, again, see the difficulty, the mediator has to remain neutral at all times. So no matter what my views, the circumstance, the case, I cannot breach that neutrality. So, you know, in my personal view, I've given you, I suppose, a policy view, an overall policy view, but my personal view is that individuals need to have somebody advocating for them if there's any safety concern. And unfortunately, the most appropriate route in that regard is through the court system. Not unfortunately, it's their remedy, should I say.
Still more questions coming in, Aisling. So maybe if I pass you on these couple of more questions. Someone has asked, why would there be a difference between safety order and barring order? I suppose that in terms of that last question you answered about the barring order.
Okay, so well, I mean, they're different applications to the court, and they're different court orders. Okay, so protection order from the outset is an interim safety order. So it's granted ex parte, as in the victim can attend court and just go into the courthouse and receive a protection order from the judge if they feel there's a safety concern there. And then there would be a safety hearing subsequent to that. With the barring order, that's where you're having somebody removed from the home. Tony, you might want to address that, working as a solicitor more than me. I'm giving the proper legal definition there in terms of safety order and barring order. I don't have the definition up in front of me, but the safety order is very much about not threatening somebody, their safety, level of safety, and there's various parameters within that. A barring order relates to residency and that person not being in the home.
Yeah, I mean, that's right, Aisling. I suppose perhaps in the context of mediation, maybe it's, you know, obviously it's leaving, so the seriousness of the barring versus the seriousness of the safety order maybe was the issue that the...
Oh, sorry. Yes, I understand the question more so now. Yes, excuse me. Yeah, well, I suppose when it comes to a barring order or safety order, again, like I should be clear, I would have a challenge either way, okay? I personally, as a mediator, would, and generally speaking, if somebody comes to you with a safety order, barring order in place, you would be very hesitant to move forward in the mediation realm. However, it doesn't preclude parties from entering into mediation. The barring order, I suppose, has a criteria level in order to meet the threshold for a judge to grant a barring order. It's slightly higher than that of the safety order. So it's on that basis that I will be making that assertion in terms of capacity to mediate.
And then there's the last question then. When you say screening, does this include mental health capacity, a capacity to understand due to the effects of drug and alcohol abuse and dependency?
Yes. So I will be assessing the parties for their capacity to decision making. Now, in Dolphin House, that would have been a very prevalent thing. That's the Dublin District Court. So a mediator is very clearly trying to establish whether or not there is capacity for each individual to make clear decisions and fully informed decisions going forward. So that would tie in.
I'll give you this last question, okay? And if there's any more questions, maybe we can deal with them after the break or at the end of your presentation. If mediation has been court ordered and not appropriate, how does it affect the parents?
So if it's being court ordered, so first of all, mediation should never be court ordered. So what does happen though in practical terms is the judge may suggest the parties attend mediation, and unfortunately parties can see that as a direction from the court, and sometimes their solicitors can say to their clients, you have to attend mediation. However, when the parties come to me, unless I'm fully clear that they're there on a voluntary basis and they're fully willing to participate in a certain way, because if they're not, you're on a hiding to nothing, they have to be willing to participate in a certain way, then I would give both parties correspondence from my stating that in my view, mediation is not the appropriate. Then they would then in turn go backward on their next date with a copy of that letter. Then it's neutral, so it doesn't affect one party or the other. It's simply a case that they would have come to me, received information on mediation, so they would have met that requirement from the judge that they met with the mediator. They were given information pertaining to mediation, and then, unless they were willing to participate, so it shouldn't affect them as parents.
Okay, Aisling, thanks for that.
I just want people to be very much assured as to how things are managed in mediation. You know, so like all mediators really will find their own way of assessing. They ask questions that are assessment questions, but you have to ensure that clients are at ease and have an ability to speak freely in the room with you. So like, if the abuse is acknowledged by both parties, it may be appropriate to proceed in mediation. But that's obviously a key tenet of it. And, you know, that also to ensure that the abused person has support structures in place, you really have to ensure that that is the case. So there are very clear policies around how we manage this, and that clearly the abused person has no fear of retribution when it comes to engaging in the process of mediation. So I know there may be more questions in that regard, but I'd like you all to keep asking them so that everybody is clear, because obviously it's such it's so prevalent at the moment since the pandemic, etc., and it's hugely prevalent in the district court. So it's something that, you know, it's a huge area for me that I come across quite a lot. And there are very clear parameters that I need addressed before I feel it is appropriate for mediation to proceed. So I'm going to move on now just back to my slides. So everything they own and everything they owe simply will be attached. That will be all of their bank accounts, bank statements, credit union statements, shares, valuation of the family home, the mortgage statement, so you can assess the equity, and it's clear when they go to their solicitors that all that information is there, and also as a way of financial disclosure for both parties. A pension benefit statement clearly stating everything within the pension down to their lump sum and their benefits on retirement, and you know, you're looking at that relevant period, which is the date of marriage to the date of divorce, and all of that information will be attached to the document, and they would then in turn bring that document to their solicitors to have it legally formalised. In the district court, it's slightly different realm in that the court will expedite mediated agreements in the district court. So if parties come to me and they want to reach an agreement surrounding access, maintenance, or guardianship, for example, and we reach an agreement and I draft the clauses therein pertaining to those areas, I would then in turn send that out to the clients. They would sign the documents. I operate in a space where I have a very strong relationship with the court clerk and the judge of the district court. So they would sign the documents, get them back to me, and I would then in turn bring them into the clerk, and he would have them listed for the next family law day to go in and consent. The parties would not have to attend the courthouse on that day. Then they would receive their court orders surrounding those specific areas that were addressed in the agreement with the mediated agreement attached. And then they have a court order, and they know that if they wish to change anything in that space, in that court order, it needs to be varied within the court. So that's to give you an insight into the process. So I've stepped ahead there post-mediation. Some parties just live formalized, okay, ruled in the district court, and then the other agreements, which would be all issues mediation, deal with everything from parenting to the pension, which could be used in divorce proceedings and consent divorce. So to give you an insight on family mediation and how to train as a mediators, I've noted up here, obviously, the route that now exists within the family mediation service, but it's not the only route. We are obviously tied in with NUI Maynooth, and the FMS are very much involved in the Masters and Postgraduate Certificate in Mediation and Conflict Intervention. So the modules in there are substantive, and then following that FMS placement. But so ultimately, once you have what's called part 1 training, which that would be, you can then apply for the interview process to get into the FMS placement. And that placement involves 2 days per week, running from October to May for an 8-month period, where you would be posted within one of the offices throughout the country, and you would co-mediate with your trainer and engage in supervision at all times during those 2 days. And following a minimum of 5 co-mediation cases with your trainer, you would then be allowed to go out and have some solo cases. So you would be given cases on your own. It would be explained obviously to the clients that you are in the midst of your training, but that you're operating with 12 solo cases under supervision. Okay, so you can invite your trainer to come in with you and help you co-mediate a case, or they can, but you're under constant supervision throughout. And following that, then you have been fully trained through the FMS. You're not guaranteed a post in the FMS, but you're trained through the Family Mediation Service training. And that in turn then gives you an opportunity to become advanced practitioner mediation status within the Mediators Institute of Ireland. So I've just noted there then some useful contacts for everybody. Obviously the Legal Aid Board, all our details of the Family Mediation Service are noted on that website also. FLAC, the Free Legal Advice Centre, the Law Society, Treoir, obviously very useful resource for all information pertaining to all of the legalese. TUSLA, MABS, the Money Advice and Budgeting Service, very useful tools on that for clients around budget sheets and how to look at potentially managing their finances in a post-separation space. The Citizens Information has brilliant information also, and explains in very clear terms all of the various legal terminology. Then the Children's Rights Alliance, the Ombudsman for Children, and the Central Authority for Maintenance Recovery. So that's just to give you a sense of some contacts that may be of value to you. The Mediators Institute of Ireland is the accrediting body for practicing mediators in Ireland. It is the only accrediting body that we have. Mediators are still unregulated somewhat in this country, and that's being addressed now through this new Mediation Council. So that's why I in turn like to bring your attention to always going for advanced practitioner status when seeking a mediator. And finally, the Family Mediation Service has a list of all the offices, which is again available on the Legal Aid Board. So folks, that's the end of my PowerPoint presentation, but I'm happy to take any questions as we move forward throughout the afternoon.
Yeah, thank you so much, Aisling. There's a couple of questions that have come in. So one is asked, where one party is not honest about his assets or income, what happens next if this is identified by the other party?
Right. Well, obviously, you know, in mediation, first of all, no marital assets may be disposed of by either party during the process of mediation, okay, unless they both agree. But when decisions are being made about financial matters, they have signed ground rules from the outset that there would be full and frank disclosure of all particulars. So all of that financial documentation would need to be brought into mediation, and I have to attach that documentation to the mediated agreement. So both parties have to have sight of all of that financial documentation, because otherwise it won't work. I mean, you're operating in a space that's non-adversarial, and it's about self-determination, and it's about, you know, parties being willing to participate in a certain way and being willing to, you know, resolve their own problems. So I have to operate in the space of my client's ability to resolve their own issues, and that self-determination is key, and that financial disclosure obviously forms part of that. Okay. So if they don't provide financial disclosure, to answer your question, I would be terminating, or provide all the financial documents, I would be terminating mediation on foot of that. Okay.
In a similar one about property in our assets, in relation to assets, would a promise of a future asset, i.e. inheritance, form part of the division of assets if it is generally accepted by both individuals or not?
So again, it's a very subjective thing. It's about each individual. In my experience, a lot of individuals would waive their rights to any future inheritances, and it has often been a case that there could be huge disparity between what those inheritances may be. One party may have already received any future bequests and may have used that within the marriage in some way, shape or form. So therefore they would feel they'd like to ensure that any bequests on the other side that the other party may have coming down the road would be taken into account. So it very much depends on the particulars of the case, but would be discussed and agreed between the parties as to how they would manage that piece.
Okay, thank you. And what happens in relation to pensions during mediation?
Okay, so pensions obviously are a huge area in separation. You know, they're sort of considered the second biggest asset. And obviously in latter years, they were, during the recession, sometimes the only asset. People were generally in negative equity, and the pension may have been the only asset of the marriage. So what would happen is both parties, if they're both members of pension schemes, they would both bring in a copy of their annual benefit statement. They would receive some kind of financial or pension expert advice pertaining to their pension entitlements. We'd explore it and we'd look at the retirement benefits and the contingent benefits within that scheme and try and assess how it's fair to manage them. Okay, so if it's a valuable pension, or if there are some pensions that are preserved pensions, they may have bits of pensions here, there and everywhere. We can't proceed until such time as they have got documentation and detail pertaining to all of those pensions. And then we will be discussing, potentially there might be a trade-off of more equity in the family home in order for the other parties to relinquish their rights in their pension, or they could be carving up one pension and doing a pension adjustment order to balance the retirement benefits for both sides. So it's a hugely important area of it. So I've mentioned you have the retirement benefits, and the contingent benefits are contingent on, you know, obviously rights are extinguished post-divorce. So you have to ensure that if there are contingent benefits attached to a scheme, that an order has been done binding the trustees to allow that former spouse, if either party hasn't remarried, that former spouse, that spouse's pension, rather than nobody getting it. So I don't want to labour on the legalese around pensions. It's a minefield. People often it goes over their head, but I would, and I'm not there to advise parties on pensions. We're there for them both to come in fully informed about their pensions. Obviously, I know quite a bit about pensions, but I would be absolutely ensuring that parties are coming in fully informed, having received independent pension advice as to what the realities of their future might look like, and the realities might look like if they enter into a pension adjustment order, if their pension is carved up in some way, and you know, if their penalties may apply in doing that, or what the realities of that might look like, so that they're making very clear decisions around it.
Okay, thank you, Aisling. Okay, just on qualifying as a mediator, what undergraduate degree is available, if any?
Undergraduate degree, no, the majority, there isn't an undergraduate degree in mediation. You would generally, professionals who become mediators usually have worked in some area prior, in that I was a former solicitor, an awful lot of my colleagues were former solicitors. You have people working there, social work, psychotherapy, counselling, and then once they had some form of a degree in a relevant area, then could apply for Part 1 training. So it's very much a postgraduate application when it comes to mediation training.
Yeah, and thank you for that. And then last question I have then is, how stressful do you find this work?
At the moment, working from home remotely, extremely stressful. I operate much better when I'm in a room together and I'm energized by people in the room, whereas remotely on a video link conference, it can be quite challenging. But we have huge supports, and it's really important that a mediator is going to what's known as supervision. So it's an opportunity for a mediator X number of times in each quarter to have a conversation with an accredited supervisor around the cases and how they're managing them and any difficulties that they may be having, and giving them a chance to offload. But it is difficult. You do bring things home with you, and when it comes to managing circumstances for children, you know, you're operating in the space of do no harm all the time. So you're trying to ensure that parties are putting the children at the top of the pyramid, and you're hoping that you can achieve a positive outcome for children. And that's my modus operandi in the room. And it's hugely satisfying when you can get to that space.
Thank you, Aisling. Thank you very much. That was great. Well done. Thank you very much.
Thanks, Tony. Thanks for your help.
Oh. So listen, I'm Tony Monaghan, and I'm going to take you on to the next part of the training today. So I'm just going to get up my slides and share those with you. As I said, I am Tony Monaghan, and I am a solicitor from the Law Centre in Wicklow. So we're based in Bray. Just a little bit about me. I am qualified 20 years. I've been doing family law, legal aid all that time. I started off in North London doing family law, legal aid there, and then I moved back to Ireland in about 2005, and I've been in Wicklow Law Centre since that time. As I said, the Wicklow office is based in Bray, and most of my time would then be spent in the County of Wicklow, but also in Dublin, Wexford, sometimes over to Naas, Carlow, Clonmel, those kind of places. So just to say that I'll be talking to you about how to access legal information, and I'm also going to explain to you a bit about the Legal Aid Board, who I work for, and how to apply for advice and get representation. And I hope that by the end of this presentation, I'll have helped to sort of demystify some of the processes around applying for legal aid and that. And as I say there at the end of the note, there will be slides available for this and also for Aisling's presentation. This slide here, so this one here is about accessing legal aid. And so I'm going to do that part of the seminar first. So legal aid is provided by the Legal Aid Board, and I just worked it out. We've been around since 1979, believe it or not. So that's like 42 or so years. But it was put on a formal footing in 1995 with the introduction of the Civil Legal Aid Act. And we also have some regulations that we use to guide us, and they're from 96 all the way up to 2017. So the Legal Aid Board provides legal advice and legal aid through law centres, and we also have private practitioner panels for district court cases. We are an independent statutory body, and we are responsible for the provision of, as I said, civil legal aid and advice. We also provide the family mediation service, which Aisling is a part of, and vulnerable witness related services and administration of other ad hoc schemes. So the ad hoc schemes, the Legal Aid Board also deals with the administrative side of the criminal legal aid system. Just the administrative side of that. The vulnerable witnesses, I was asked this at the last seminar on Tuesday. We provide service to vulnerable witnesses which are people in rape cases that are going to be asked questions on previous sexual history. So that's what that references to there. But we also do represent clients with other vulnerabilities, such as people that might be hearing impaired, have language difficulties or learning difficulties. So we have 30 law centres throughout the country, and we are in 23 counties, and we have approximately 105 full-time equivalent solicitors. So as I said, the law centres, we have 23 law centres throughout the 30 law centres throughout the 23 counties. The counties that are missing law centres are Roscommon, Leitrim and Carlow. But as you'll see from that little map that I have there, you know, we're pretty much well dispersed throughout the country, but and those three counties that don't have their own law centre have access to law centres in their surrounding counties. So for the likes of Roscommon and Leitrim, there's Galway, there's Sligo, there's Mayo, or Castlebar as it is. And for Carlow, then we also have the Wicklow, Wexford, Waterford, Kildare. So there's quite a few for them. Some counties have more law centres. So for example, Dublin has quite a number of them. Cork has 2 and Galway has 2. Okay. So I'm going to look at 2 things with you here, and it's who can apply for legal aid and how to apply for legal aid. And I'm going to look at who can apply first. And in relation to that, there are 2 tests, and these are the means test and the merits test. So the means test is a test to basically see if your disposable income is under €18,000. And in working that out, there are certain allowances that we take into account. For example, we will have allowances for childcare, for dependent children, for spouses, for partners. So they will get an allowances for those. We also have to, the merits test also means you have to pass the disposable capital test, which means you must have a disposable capital of under 100,000. The thing about a disposable capital is we don't take into account the home in which you live if you own that. So if you were a couple living in the family home and one of you applies for legal aid and you have equity in that house after you just take away the mortgage of say 200,000, you'll still be eligible for legal aid because the family home where you have your where you're living is not taken into account. We then have automatic eligibility for certain welfare recipients. So this would be recipients that are on the very basic social welfare. So that would be the job seekers. Now, in terms of income, however, the Legal Aid Board do take in certain payments into account, such as HAP, FIS, Family Income Supplement, and the likes of maintenance. But for somebody that's on the basic job seekers allowance, they will be passported, which means all they have to do is produce their certificate really that they're on social welfare, and they will get access to legal aid. We then have what's called a merits test, and this is something that is done probably at a later stage, usually when the client meets with their solicitor. And because the Legal Aid Board is a statutory body, we have to, we're answerable ultimately to the taxpayer at the end of the day. We need to do a balancing exercise to make sure that in a nutshell, what we try and do is question when the person comes into us. If this person had to pay for this service privately and go to a private solicitor, would that private solicitor recommend they spend their money on that service? This doesn't really apply so much in the cases of family law because, you know, once you meet the criteria for your divorce, the 2 years, 3 years separation, and there's no prospect of reconciliation, then chances are, I mean, that in itself is passing that merits test. But it might be in some other cases, for example, where there's a case where there is no defence to an application that has been brought. But it's just to know that it is there. Okay, so how do you go about applying for legal aid? There are lots of different ways to do this, and you can help your clients and just explain some of these to them. The first way you can do is by going online to the Legal Aid Board website. And the next slide, I'll just show you that briefly. So here's a screenshot from the front page of our website, and there's an arrow there to apply online. And when you click on that, what happens is you'll be brought to a application form template, and you can complete that. And the thing I like about it is that you don't have to complete it all in one go. You can save it, you'll get a unique user number, and you can go back in. So some clients might need help with filling out that form, so that's an option that they could save that and maybe go and get somebody to help them finish it. Or maybe they wouldn't have all their paperwork that they need to fill in the form. They can go off and get that. Also on the page, the web page, at the bottom of the screen there, you'll see download the application form. So you can also do that, like if your client doesn't have access to a printer or something like that, you could help them print out the form. And it's the same as the copy that they can get from the law centre. And that in itself is another way to apply for legal aid. You can call into the centre. Obviously, subject to COVID at the moment, or you can phone up. And if you phone up, what we often say to clients is make sure it's the applicant that's phoning up, the person that wants legal aid. Sometimes you might find that a concerned grandparent rings up on behalf of an adult child who's having access issues, something like that. And what we would say to that person is, look, can you get your son or daughter or whatever to ring back in, and we will, we will talk to them and take some basic details. Because all the information that is gathered from even that first phone call, all will be put together as part of their file when they become an applicant or a client of the law centre. Where do you go to apply? How do you go about choosing a law centre, and what are conflict centres? So I'm just going to bring you back to that map we had there earlier on. So as you can see, there was a concept that you could only apply to certain law centres if you live in that county, but that's not the case. So you can apply to any law centre. A lot of people might, for example, apply to Wicklow Law Centre who might just have a case in Wicklow, but they could be living somewhere else. I would have had clients that maybe have come from the Midlands for an application that was being heard in the Wicklow Circuit or District Court for one reason or another. Perhaps the other party was in Wicklow and issued those kind of things. But you can even a person in Dublin can apply to Wicklow and vice versa. So you can apply to any law centre. And in terms of Bray, we would have clients from South Dublin down all the way down to the start of Wexford applying to us for legal aid. So that's one thing just to know. You can apply to any law centre. In terms of the conflict, what I mean by conflict centres, so if both of your if both parties to a divorce are eligible for legal aid, and one has applied to, say, Newbridge Law Centre, the spouse can't apply to Newbridge Law Centre, but they won't necessarily know when they ring up Newbridge that their spouse has applied, but they will be told that there is a conflict and they'll be given a specific letter for that, and they'll be assisted with how to find another law centre to represent them. The application forms that I was talking about earlier, these are the information that the clients put into them is so important. As well as your personal details and contact details, you're going to say who the other party is so that we can do a conflict check on them. And it's also going to help us decide if how urgent and what case that case is. So as Aisling mentioned in the mediation, there are waiting lists and we're no stranger to them in the law centres either. So some cases, unfortunately, do have to go on a waiting list until a solicitor in the law centre can deal with them. But what does not go on a waiting list would be the likes of domestic violence applications, the protection orders, the safety orders, barring orders, they will not go on it. Childcare, so the children being brought into care on interim care orders, emergency care orders, or supervision orders. Child abduction proceedings under the Hague Convention, so applications there would be children being brought into Ireland from abroad by a parent or being removed. Also would get advice on a priority basis. And other issues will be cases that would have a statute of limitations, so something that would mean we have to issue the case straight away or in a very, very short time. For example, the likes of cohabitation is something that has to be issued within 2 years of their separation. So if it's only 6 months before the end of that 2 years, we really need to get to see them pretty soon. So the more information, as I say, they put on the form, the better. So what goes on our waiting list then? So on the waiting list would be the divorces and the separations. Most law centres always try to keep their waiting lists under the 12 weeks. And on our website, there is a list of the law centres and what their current waiting lists are. So you can have a look at that. So in terms of accessing legal aid and the continuity of your representation. So I just wanted to set out here what it's like for your client when they come in. So once your client has been assessed as being eligible for legal aid, they've passed their means test, they will come in to see their solicitor. And when they come in for their first consultation, they will have to pay an advice fee. And so it's very important to let your clients know that legal aid is not free. It's means tested, as we know, and then you have to pay a contribution to it. So I'll talk to you a little bit about the contributions as we go on. But for now, I just want to explain just the process of what happens when the client comes in. So they come for the first consultation, they pay an advice fee, which is a portion of their legal aid contribution. The solicitor will take all their details, find out what it is that they want advice or representation on, and may at the end of that meeting decide that that client needs a legal aid certificate to issue divorce proceedings, for example. If that's the case, then at that stage, the client will be asked to pay the rest of their legal aid fee. As I said earlier as well, we have a private practitioners panel. So some cases, particularly district court cases, and perhaps a lot of your clients would have dealt with the private practitioners panel. A lot of our district court cases will go to private practitioners. So we have a list of solicitors per county, and we would give this list to the client. Different for the private practitioner clients is that they will get their legal aid certificate upfront, and they will have to pay their legal aid fee upfront before they go and meet their private practitioner. And as I said, what is dealt with by the private practitioner is the access, maintenance, custody, guardianship, and domestic violence. They're also done in-house as well, but often law centres would refer them out to private practitioners. So these are the fees. The minimum fee is 130. So if your client who's going for divorce is on social welfare and job seekers, then their fee for legal aid and advice will be 130. The advice fee, when they come in for their first consultation, would be the 30 euros. And then their aid fee is 100 euros, it'll be the balance. And that would be paid when they get their certificate. The maximum that a person will pay if they're going to the district court would be 415 euros. So do you remember at the start I was explaining that people under 18,000 can qualify with disposable income, can qualify for legal aid. So those people, so depending on where you are in terms of the your income, you could pay a little higher than the 130 euros, and you could pay up to as much as 415 in the district court. And it says there up to 5,000 in the circuit court. But as I said on to the group on Tuesday, I haven't as yet come across a case that has had such a high contribution as that. There is an installment option nonetheless for these people, and they can just let their solicitor know, and we will put in place and look into ways of putting in place an installment option for them, particularly those with the higher fees. There are exclusions to the contribution. So for example, if you are eligible for legal aid, so you're eligible first, you can, and you need to bring domestic violence proceedings, or you need to defend childcare proceedings, you do not have to pay a legal aid contribution for that. And the reason behind that really is that people in these situations shouldn't have to worry about money in terms of bringing these important applications, or indeed defending these important family changing applications. At the end of a case then, so we've talked there, I suppose, about the costs at the start of the case. At the end of the case, there are also potential costs. If a client of the Legal Aid Board in a divorce or a separation comes into a money or a settlement as part of the proceedings, then they may have to pay their legal costs out of that money. So this is, again, it's a really quite important area as well for clients to know about from the outset. Circumstances where this might arise, for example, is if a court ordered that the family home had to be sold, and both parties were going to come in to say, or at least the legally aided party was going to come in to say, let's just say €100,000. They may have to pay their legal costs out of that €100,000. So at the start, I was showing you the cost to the board of running these cases. So it was $415 for the district court and up to $5,000 for the circuit. The client may have to fund some or all of that. Obviously, different cases are more litigious than others. So depending on how litigious it is, will determine how costly the case is to run. So obviously the cases that have more applications into court would have a higher bill than those that don't. So that's taken into account, along with the amount of money that client has been awarded. Some clients might only get 10,000, in which case, you know, even if their bill was 1,000 or 2,000, the board would take that into account when deciding what costs they have to pay. There is also an option for the parties to apply for a waiver of their legal costs, and that's something that will be applied for at the end of the case, which again, it's filling out the means test application that you have and bringing that to the Legal Aid Board. The waiver of costs is based on hardship. So you have to basically be able to explain to the court or explain to the Legal Aid Board that if this money is retained, I will suffer a financial hardship. It's not as simple as saying, I need this money for X or Y. You have to explain the financial hardship and the purpose of that. Hi, Aisling, do you have a couple of questions?
Hi, Tony. Sorry to come across there. There's a few questions. I think one or two of them you could answer pretty quickly. Would somebody on PUP payments be eligible for legal aid? That's the PUP payment.
Yeah, I believe they would. Again, they need to just make the application. And I think the thing is, let anybody make the application, and then they'll find out if they're eligible or not. If they're not eligible for the 130, the chances are they'll be eligible for just a slightly higher contribution.
Okay. And can you choose your solicitor, or are they chosen for you?
Yeah, that's a really good question. So in relation to the private practitioners panel, you're given a list of solicitors from that panel, and it's the client can pick any solicitor on that panel to represent them. In terms of solicitors in the law centre, usually you will be assigned to a particular solicitor in the law centre. I mean, law centres outside Dublin on average have between 2 and 4 solicitors. So you will be assigned one of those. The only other thing I'd say is if there was a breakdown in relationship between your solicitor, then you can obviously look to change solicitor, but from a law centre point of view, you'd probably be assigned one from the manager.
Okay, and just one other question then. Just missed when you were talking about the exceptions of where people have no fees, the waivers.
The no fees. So yeah, sure. So you don't have to pay legal aid contribution if you are bringing a domestic violence application. So if you need if your clients need to get a protection order or an interim barring order, something like that, they can apply for legal aid. Assuming they're eligible, they will not have to pay a contribution. Same for parents when they're defending childcare proceedings. They also, assuming they're eligible, will not have to pay a contribution.
If you are a homemaker with no income, are you assessed by your husband's income, which may then make you ineligible?
No. I mean, because you're separating from that individual. So no, you wouldn't be. You'll be, I mean, if you have no income, you'll be assessed as having no income. Perhaps you'll have, you know, and sometimes in those cases, the wife might be getting, it's usually the wife might be getting an allowance of some sort from the husband. So we might say that that's her income and look at it that way. But usually, no, you would definitely not take the whole house income into account, no.
Okay, and you may have addressed this earlier, but I'll just pose the question, just as you're on solicitors, do you have the same person throughout the case? Yeah,
I mean, if you come to a solicitor in a law centre and you're assigned, then yes, in theory, that would be your solicitor throughout the lifespan of the case. Now, obviously, you know, things happen, solicitors move on, change law centre or whatever. So you may have a change in solicitor, but usually it will be the same solicitor. And I think I have a couple of slides later on about other people in the law centre working on your case. So I'll mention a bit more on that there. But yes, you should have continuity in that context. There might be some problems, I think, in the district court. I would notice that on the private practitioners panel, sometimes I would sometimes see the barristers might be sent instead of the private practitioner solicitor to cover a case. So maybe some of those clients might experience meeting different people, but when you're being dealt with, particularly with separation divorce cases, which is the majority of the conversation today, they will be dealt with in-house and usually by one solicitor, yeah.
Okay, again, same subject. If you don't have confidence in your solicitor due to their lack of experience or understanding of domestic violence, can you request another? Can a solicitor refuse to work or continue to work with the client? There is a perception that often the solicitors working with free legal aid are inexperienced and recently appointed and therefore not able for these complicated cases, re domestic violence or childcare. How is the solicitor chosen and matched with the client?
Okay, I mean, I can only speak about my experience where I work and in my law centre. So, but certainly, if I just take the last, the bit about how our clients and solicitors matched. I mean, obviously, when we refer clients to the private practitioners panel, we give them the list, and then it's entirely up to the client to ring around the solicitors, and really they should ring them around and get a feel for the solicitor. Do they understand me? Can I, you know, are we on the same wavelength? You are putting your life into somebody's experience to put that forward to a court on your behalf. So absolutely ring the solicitors around and find one on that list that you feel comfortable with. In terms of the solicitors in-house, I mean, how that they are assigned is really up to the manager of each individual law centre. I know in my law centre, for example, if I've acted for somebody, say in their separation, or maybe I did domestic violence for them in the past, they might be assigned to me because I know them, you know. If a client is unhappy with their solicitor, whether it's on a private practitioner panel or in-house in the Legal Aid Board, for whatever reason, inexperience, or you just don't get on or whatever, it's absolutely, the client is entitled to look for a change of solicitor, and there is a procedure to do that. Even with the private practitioner scheme, I think you can contact you can contact the office in your area, and they will help you and just tell you how to go about that.
Just for clarity for people, in domestic violence, where there's financial abuse, applicant has no access to her own money and the family home is over the threshold. Is that taken into account for legal aid?
Okay, the family home is not taken into account if they're living there. So assuming she's coming from the family home, and that won't be taken into account. You got kind of cut off, so I think I answered that was all the question. Was whether the family home was being taken into account. Is that right, Aisling?
Yes, and she has no access to her own money due to financial abuse. But yeah, you clarified that to my understanding.
Suppose in terms of access to her own money, if she has money and she has accounts in her own name, then they will be taken into account in her means assessment. But I mean, if there are, for example, accounts in her husband's name and she has no access to them, then no. And as I said earlier, the joint income is, you know, the family pot, when you're splitting up from your husband or your wife or whatever, is not taken into account. It's only your pot.
Okay, and can you apply for a barrister under legal aid, and do you have to pay?
Well, a barrister can often come with a solicitor. So if you are applying for a divorce or judicial separation, if the solicitor makes a recommendation when they're applying for a legal aid certificate for a barrister, when they feel they need one, and then so whatever your legal aid contribution is, so say it was the 130, you can get your barrister And assuming you don't come into any money at the end of the case, the 130 is the extent of what you paid, even if you had a barrister. Okay.
Okay. I'll just give you one more, Tony, and then I'll leave you alone. So somebody said, sorry, I didn't understand this answer. Is there a means test on domestic violence cases, or are all victims entitled to legal aid?
Yeah, no problem. I'll clarify that again. So the first perimeter is the person has to be under the 18,000 disposable income or the 100,000 disposable capital. So they have to pass that rule. And once they pass that test, and once they pass that test, then for bringing an application for domestic violence, you won't have to pay contribution. So I was just before the break there, just trying to bring you through the process with regards to getting legal aid. And I was getting to the point where the client was going to have to pay the legal aid certificate fee. And that is when the client, so say for example, in a divorce case, they want to go ahead with their divorce, the solicitor will apply for a legal aid certificate for them. That will be sent out to them. They've got 1 month to send it back in and pay their fee. If they don't bring it back in the month, then in theory, the certificate lapses. So it's important that they do get it back in. And the certificate is very important because the solicitors cannot go into court without that certificate being in place. And then touching on one of the questions there, so when you are represented, when one of your clients is represented by a solicitor at the law centre, they'll meet that solicitor at the outset, but there are other people in the law centre that will help out on their case. So the law centre works as a team, and in that team we have law clerks or paralegals, and we have clerical officers. So our law clerks will assist the solicitors in terms of preparing our paperwork, and our clerical officers will be the ones doing a lot of our typing. They will be the people answering the phones, and things like that. So, you know, so there is a team working together. And of course, if there is a barrister, then also the, if there's a barrister on the case, then of course the barrister would also be a part of that team as well. But your main contact will be with the solicitor and possibly the clerical officers when you ring in and maybe for an update on your case or something like that. So when should you know, if your client is saying to you, you know, should I go and get legal advice or whatever, if they feel anytime they need to get advice on something, then absolutely they should go and get advice. There's no bar on them getting advice as many times as they like, that they can get advice. The only difference is that if somebody has got a private practitioner certificate and has been in the district court with a private practitioner for say custody and access, and within a 12-month period of that cert being granted, they need to go back to court again. They won't get the private practitioner that time. They'll go to a law centre solicitor that time. So that's the only slight exception. So there's absolutely no problem. Don't think that you can only go to a law centre because you have to take court proceedings. Clients can come and just get advice. I would often have people who would come in who haven't even separated yet, haven't mentioned it to their partner, and want to come in for advice on, well, you know, what's it going to entail, what's the court process like, and things like that. And we're not going to force anybody to take any case if they don't want to. It really is, it's their case at the end of the day and their decisions to be made, their decision to make. Naturally, if they've been served with any court papers, they should go and see somebody about it and not, you know, try and make it think it'll just go away if they don't open the envelope or whatever, which sometimes does happen. It's so important that they go and get advice if they get some court papers served. Also, if they've been asked to sign anything, official paperwork, a mortgage, property transfers, so like say, for example, one spouse wants to increase the mortgage and the other spouse isn't so sure about it, maybe they should go and talk about their options to a solicitor before they go and do that. property transfers, again, quite common actually when people have tenancies, council tenancies, where one might ask the other to sign over the tenancy to them. So there are implications for them on things like that. So it is important that they go and get themselves some advice so they know what they're getting themselves into. So then I just want to, the next stage then is I'm going to look at is sources of information. And this is kind of really important because particularly when you have clients that are on waiting lists for a bit of time before they're seen by a solicitor, it's important that, you know, that you can give them some information and or direct them as to where they can go to maybe get some comfort while they're waiting to see a solicitor. And as we all know, that family law problems are often accompanied with other things, such as mortgage arrears, domestic violence, as we've spoken about a lot today. Literacy issues can certainly play a large part in things, mental health, addiction, and homelessness or threats of homelessness. So I'm just going to talk about these organizations briefly. And I've got at the end of my presentation, I have all of these websites, URLs, and a couple of other ones that I would have used over the time. I just attached the presentation that you'll get at the end. So MABS, the Money and Advice Budgeting Service, are an absolutely excellent resource for providing support for clients that are in any kind of debt situation, whether it's arrears on their mortgage, arrears on a utility bill. They will help with budgeting, helping the client to budget, how to do a financial statement. They also have the Awalia scheme, which is in conjunction with the Legal Aid Board, where they can advise and liaise between the client and the bank in terms of finding a solution that works for that household on mortgage arrears or where there's a threat of a repossession. You can also, under that Awalia scheme, you can get the client can get a certificate for free advice and free legal advice and or free financial advice. So that's a really good good service there. Women's Aid and Men's Aid both have excellent supports for people that are needing to bring an application to court for domestic violence. Both of them will assist people in bringing the necessary paperwork, getting the paperwork together for the protection order or the interim barring order. And they will also accompany them to court. So particularly courts outside Dublin, where we don't have dedicated family law courts, a domestic violence case could quite easily go into the local criminal law day or the civil or licensing law day. And that can be very intimidating for people. And I think it's really beneficial service that Women's Aid and Men's Aid do by providing that support for people at court. They obviously can't go into the courtroom unless they're expressly allowed because of the in-camera, the private nature of the family law proceedings. But they're there to support them whilst they're waiting. Mercy Law is another organisation, and this is a charitable law firm, law centre in Dublin, and it provides advice clinics to homeless people or people at risk of homelessness. And they provide some of those clinics at actual hostels, and they do provide in some cases representation. So again, another really good resource for clients whilst they're waiting to get other family law issues dealt with. Treoir, I know you're going to have a training from them specifically in a couple of weeks, and you'll know that they provide advice about single parent families, and their website is absolutely brilliant in terms of the information they provide on the likes of guardianship, custody and access, maintenance, and it's just put so succinctly, you know, I couldn't explain it better myself. I think it's really, really, really good. Lastly on this list, we've got citizens information. And what I wanted to say here, I mean it in terms of the actual advice clinics and centres that they have, although a lot of those are closed, I think, or maybe appointment based now because of COVID. and also their website. Website is fantastic for the likes of advice on various benefits and things like that. And I would often send my clients down to the Law Centre for, particular, just to get some advice on how, what social welfare entitlements they're entitled to, particularly if they're newly separated and perhaps like a housewife who has never been, since she was married, financially independent. So really good support there. The Citizens Information also have an advocacy service for vulnerable clients and for clients with various difficulties, whether it's learning difficulties or mental health problems. I would have had a number of clients that have had various injuries that have some sort of brain trauma that requires them to have an advocate, and Citizens Information are absolutely brilliant to provide somebody that will do that in terms of helping that person organize their papers for court. I have to, just a brilliant, really, really good service, and it's helped clients no end. It's really, really good. Just to mention briefly about FLAC, so and the role of FLAC. So I just want to explain that FLAC is the free legal advice. FLAC stands for the Free Legal Advice Centres. They are separate from the Legal Aid Board. We are not the same organisation at all, and they provide advice through clinics, and those clinics are staffed by volunteers who are usually qualified and practicing solicitors and barristers who do this in their free time and pro bono basis. FLAC have an excellent website. I think their website provides absolutely amazing information that you'll be able to get there in terms of what services they provide, when their clinics are on, and where their clinics will be. They're all up there on their website. Again, they're probably slightly restricted because of COVID, but hopefully that'll improve. And in terms of the advocacy, they do a lot of special interest or public interest matters, and also they would give advice on the likes of debt, employment, family. Again, they have all that set out, and I think I wouldn't do them justice to try and explain it really any more than that, but do check them out. So there you go. I've just done a list there of various organizations, and some more I've added in. Ones that I would use as well, just to give numbers and things to clients that are really, really useful. And I'm sure a lot of you already know these. In particular for me, I quite like the National Literacy Agency programs. They have on their website a list of classes for clients who may have literacy, reading and writing issues. It's something that's very common, but people don't like to talk about it. So, it is there and they might not know that. I didn't mention Threshold, but that's a homeless charity and also provides loads of information. So that's my presentation. So unless there is any questions, I'm happy to take any questions that you might have.
Hi, Tony. Yes, there's a few more questions. Sorry, hold on a moment. Are clients seen as difficult if they change legal team?
No, I mean, some people might have a reason to change legal team, I mean, look, some clients, as in all walks of life, some people are easier to get on with than other people. And, it's for the professionals to try their best to get on with their client and speak the same language as the client, and to make that relationship work. But at the end of the day, we have a responsibility to get a result for the client, and so look at if they need a change of solicitor, that they will not be prejudiced for that.
So what is the normal response time in terms of email correspondence from a solicitor, and how hard is it to change solicitors once in the middle of a case if there is no response or communication from a solicitor?
Yeah, so I suppose the thing with correspondence is these days is that when correspondence is coming in by email, whilst it's an instant media, and I'm only speaking from my own personal experience here, but whilst it's an instant media, the solicitor may not be able to instantly get back, unfortunately. And I suppose it's up to each individual solicitor how they manage that. If a client isn't happy with the speed with which the solicitor is communicating to them, then they should raise that with the solicitor, and then if that's not dealt with, they should raise it with the managing solicitor. And I mean, that's a complaint, and there is a process for that, and you're entitled, as a client is entitled to have their concerns dealt with. Changing solicitor in the middle of a case, it is absolutely possible. I mean, you know, you can absolutely change. I would have taken over cases, say maybe have come halfway from a private solicitor, and yes, of course, it takes a bit of time to get up to, for the new solicitor to get up to speed on the case and the nuances of it all. But, you know, it's absolutely possible, definitely.
Okay, so if you just go for advice, do you have to go through the application process?
Yes, you do. You do, absolutely. So, and again, you will then also have to go on a waiting list if it is a waiting list issue. So I mean, if the law centre has a waiting list. So if you're looking for advice and separation, like that client, you know, the people I've mentioned who might say they're only thinking about getting a separation, they would have probably been on a waiting list before they came to see the solicitor. Okay,
and is the 18,000 threshold applicable even if there are children under the care? Other words, if a person is on 21,000 and have 2 kids, they still do not qualify. Is that correct?
No, so you'll get, there are allowances. So say somebody whose disposable income comes to 21,000 on their calculations of it. You're also entitled to dependent allowance for your children, so there will be a deduction for that, and also you can get childcare. So if your child is going to creche or play school or whatever it is, you can get a reminder, you can get a deduction for that, which all of those deductions will help hopefully bring them in under the threshold.
Okay, and if a person contacts the law centre for advice only and doesn't progress to representation, does the fee structure still apply?
If they if they come for advice, then they pay an advice fee only, and they don't go ahead. It's just the advice fee, because you're not getting a legal aid certificate at that stage.
Okay. If you have a judicial separation, do you need to get a divorce?
Well, if you want to remarry, you do, but I mean, to all intents and purposes, the only difference is the remarrying bit. So I suppose it's up to individuals, but I often think it's, you know, people are, it's a long, sometimes, you know, people think, oh, I've spent 3 hours or 3 years going through a separation and I got my separation order and I have to go back and do it all over again. But hopefully at that point, it could be just a rubber stamping exercise in terms of the divorce, and it won't take as long, you know, but yeah.
A couple more, Tony. Just if separated 2 years and estranged husband is now in rehabilitation due to COVID, can a divorce still proceed with only one party?
I'm not sure I understand that.
So if separated 2 years,
yeah.
So she's saying meets the criteria for divorce, and estranged husband is now in rehabilitation due to COVID.
Okay.
Can a divorce still proceed with only one party?
So I mean, if that attendee is still on, maybe they could clarify, because I don't really want to go and answer it wrong, but I mean, I suppose I'm not sure if the person is is competent, the person that you, because she mentions the person being, or he mentions the person being in rehabilitation. So, so obviously, you know, in terms of issuing proceedings, you have to be able to prove that you've served somebody, and the judge has to be happy with service. But in terms of the actual hearing of a case, at the end of the day, really only the applicant needs to be there if it's on consent, you know, because the applicant gives the formal evidence. I'm not sure that I've answered that right, but maybe if the person is still there, they can just clarify that.
Okay, I'll just go to another one for a moment. So do Mercy Law only work with clients based in Dublin?
I'm not sure. I'm not sure. If they are, I'm sure that they may have connections with other community law centres around the country. It's a good question. Maybe if you have a look at their website, they might be able to provide you with that information. Sorry, I don't know the answer.
And that's it, Tony. Apart from that one query about rehabilitation due to COVID, can a divorce still proceed? I wonder if she really asking the question if she can issue proceedings. However, I'm not sure either. So if the attendee is still there, if they'd like to maybe highlight exactly what they are asking. But that's it in terms of all of the questions.
Right. Okay. So, well, I'd like to thank everybody for all their replies and their questions and stuff. It's been great. I hope I've been able to help. Thank you.
Okay, so I'm coming back in to thank you both very much for a very comprehensive presentation this afternoon. Like you, this is the repeat of the one that happened on Tuesday, so it's been a bit of a marathon for both of you. Again, complimenting you and thanking you so much for the effort you've made in relation to the questions and answers, and we know that some of them mightn't have been as clear as you might have liked, but you've made every effort to answer them as best you can. Again, to say a very big thanks to the Legal Aid Board and the fact that you're representing them here this week in this particular part of the series of modules. Thank you very, very much, and we wish you well, and we hope that this has provided understanding, which is the big thing that was at the point of these series of webinars, and also knowledge and in relation to the issues that some of you may be working on. So we look forward to seeing people on Module 3 on the voice of the child. And again, a massive thank you to Tony and Aisling for their presentation today. Thank you.